I'm Peter Edelman, and I'm happy to have the role of introducing the next panel. Of course, not only was the last panel so fantastic, let's just say thanks again to that absolutely incredible panel. But actually, Pam Carlin introduced the panel, so I'm out of here. With the usual terrific planning that goes into this convention, the panel that we are going to have, Beyond the Broken Beltway, State Courts, Legislation, and Cities as Venues for Progressive Change, follows really exactly, perfectly on what we just heard in terms of the wonderful story and progress that Windsor and everything else that goes with it says. I was reminded of, since I worked for Robert Kennedy and since I love the quote and also was reminded by my friend David Lyles here, you all know that Robert Kennedy talked about sending forth a tiny ripple of hope, and when that happens, crossing each other from a million different centers of energy and daring, those ripples build a current which can reach down the mightiest walls of oppression and resistance. This conversation is, as was the previous one, is about turning those ripples of hope into those great forces of change. There are really two things that, there is a difference between the sort of case study that we just heard and what we're going to hear, although they overlap. But that is that Windsor didn't happen, as we heard, without things happening city by city, state by state, locality by locality, and then building up, being those ripples of hope. And of course, while we had Brown v. Board of Education with the judicial steps that took place up to it, we had a civil rights movement. And the things that have happened that are historic in our country, and we're celebrating the Civil Rights Act of 1964 now this year, that too was from people. It was a movement, and it was the ripples of hope coming together. But there's another aspect to this, the question, and in a way, the idea that we start the title of this panel by saying Beyond a Broken Beltway, that implies that what we're going to talk about today is somehow new and somehow a defense weapon or something that we do when we've got a Congress that won't do anything worthwhile. Everybody who works at the state and local level will tell you that that's a pretty dumb way of starting the conversation. Let me say, I mean, I love whoever came up with the title, but because working at the state and local level for change is as old as this country. And it has been something that we need and something that many of us have done and many of you are doing now. And those of you who are thinking about students, who are thinking about careers, I hope you have up there in equally neon signs to yourself the possibility of doing your legal work in legislation for the public good, or in getting legislation enacted for the public good, for social justice, all over this country, whether it be at the state level, in the state courts, whether it be in localities, whatever it is, and that's who's represented on this panel. And even if what's going to go on in a particular state isn't something that necessarily is an issue for the next state. And so therefore, I mean, sometimes you build, you get going in 10, 20, 30 different states. Sometimes you're just doing what's needed in San Francisco. And so that's our subject here, and my job is simply, having made that little set of remarks, to introduce our moderator. I mean, we've gotten really sophisticated here. You have an introducer of the moderator, and then the moderator about that. I mean, you know, it's going to be all done between me and Scott before the rest of them get to talk. Anyway, our moderator today, and I do want to tell you that ACS, very important from your sponsor, a project for state courts. There's a terrific report that everybody received. You all have it, and I hope you all read it, on the whole question of what's happening about money flowing into state court elections. And so take a look at that. Take a look, if you're interested in particular in getting involved in ACS's project on state courts and its important work, do see David Lyle or Sarah Knight of our staff to learn more and get involved with that. Now, Scott Lemieux is a professor of political science at the College of St. Rose. He's a graduate of McGill University, received his PhD from the University of Washington. He's one of the leading critics, along with our own Reva Siegel, of the backlash theory. That is the notion that's been put out there by too many people, that, or at least some people, that litigation to vindicate constitutional rights is inevitably counterproductive because it generates an overwhelming political reaction. Scott is the author of a forthcoming book which debunks that argument. So that's not our subject today, but I think he wouldn't mind the plug for his book. And he is a regular contributor to the American Prospect magazine. He writes on law, politics, and baseball at the blog Lawyers, Guns, and Money. Oh, okay, got that? All right, welcome, Scott. Welcome, all of you. Thank you.
I must say, when David asked me to do this, I was not told I'd be following Pam Carlin, so I'm not sure. So please grade me on an appropriate curve. So I'm very pleased to be invited to do this panel, which I think is very important. And I know that I'm going to learn a lot as well, because certainly, like many people in this room, I've spent a lot of time thinking and writing about the sort of disturbing neo-Confederate turn in Republican politics that obviously we've seen, perhaps the most important social welfare legislation since the Johnson administration very nearly struck down, with 5 justices endorsing theories that would take us back to a pre-New Deal conception of the Commerce Clause and a pre-Monroe administration conception of the Necessary and Proper Clause. We've seen one of the most important provisions of the Voting Rights Act struck down, even though Congress was explicitly authorized to pass the legislation, and no part of the Constitution forbids it. I was going to say that the equal sovereignty of the states theory that Roberts used was unprecedented. I must admit that it was once endorsed in a 7-2 opinion, with a leading opinion written by the Chief Justice of the United States. I thought Republicans actually thought that Dred Scott was wrongly decided. I guess we're not, we can't even agree on that anymore. So obviously in a context in which Republicans on the Supreme Court are literally adopting John Calhoun's constitutional theories to obstruct civil rights enforcement, the need to maintain a robust federal power is very important. But having said that, even if we want to keep one eye on that track, an enormous amount of what should interest us in terms of politics and law happens at the state and local level. Even in a world in which the federal government is empowered to solve problems, a lot of things are going to be worked out at the state and local level, which is indeed one reason why I think introducing these sort of arbitrary restrictions is unnecessary. Many of the challenges that we face, including mass incarceration, problems with the administration of justice at the local level. Many of these things, even if they have a federal component, are primarily, state and local problems that have to be dealt with there. But I also don't want to be pessimistic, because there are many opportunities for mobilization, for political progress, for advancement at the local level as well. And I'm hoping that we're going to spend some time talking about those. We should remember that the man who coined the term, the states being the laboratories of democracy, was not an antebellum or a Gilded Age reactionary. It was the great progressive Justice Louis Brandeis. And so we should always keep in the back of our mind, as we fight for robust federal power, to keep in mind both the opportunities and challenges that exist at the state and local level. And fortunately, we have a very illustrious panel who will help us out with this, and I'm going to stop because I'd like to turn it over to them. I do have a bookkeeping thing before we get into it, that I should mention that this session has been approved for CLE credit. So if you want CLE credit, you just sign in the attendance record at the table outside of the room, pick up your certificate of attendance, and then fill in an evaluation form and give it to the CLE table at the end of discussion. So for people who need that, please do that. So without further technicalities, let me introduce this fantastic panel. Joanna Bailey is a full professor of law at Emory University School of Law in Atlanta. And her work focuses on empirical analyses of legal changes and legal institutions. Her recent research has empirically examined issues related to the healthcare industry, tort reform, employment law, corporate law, and judicial elections, which we're obviously spending a lot of time on. She's published broadly in the top national law reviews, legal journals, and peer-reviewed economics journals. So she has an economics background as well as a law background, which is part of what makes her empirical work so formidable. And in addition to publishing these dozens of academic articles, Professor Shepard Bailey is also the author of 2 textbooks, The Economic Analysis of Law and The Economics of Industrial Organization. Her research has been discussed on CNN Sunday, National Fox News, The O'Reilly Factor, and it's also been discussed in the Wall Street Journal and the New York Times. So a broad coalition of journalists has discussed her work, deservedly so. And she has considerable experience as both an economic and a statistical expert, and has authored numerous expert reports, testified at both deposition and trials, and provided public policy research and white papers for many clients. Dennis Herrera is a city attorney at at the city of San Francisco, a position he's held since 2002. Under his leadership, the city attorney's office has transformed into the nation's foremost example of a government office fighting for social, economic, and political justice, going to court to protect consumers and to stick up for universal health care, common sense gun laws, and public education. In 2009, he joined the city of San Francisco as a plaintiff in the lawsuit to overturn California's Proposition 8, something we just discussed, which banned marriage equality in California. And the Supreme Court restored marriage equality to California in the Hollingsworth versus Perry decision. Prior to his election, Herrera practiced maritime law in San Francisco, and he was the chief of staff of the U.S. Maritime Administration in Washington. And he graduated from George Washington's School of Law in 1987 and joined the ACS Board of Directors in 2009. Nick Rathod is currently the executive director of the American Legislative and Issue Campaign Exchange, or ALICE. Prior to ALICE, Mr. Rathod served as the director of state campaigns for Mayor Bloomberg's Every Town for Gun Safety, where he directed state legislative campaigns for the organization. Mr. Rathod also served in senior roles for the Obama administration as the Consumer Financial Protection Bureau's assistant director for intergovernmental and international affairs, where he helped in building the structure of the new bureau. And prior to serving with the CFPB, he served as a special assistant to the President of the United States and Deputy Director for Intergovernmental Affairs at the White House. And he also served as Director of Intergovernmental Affairs for the Obama-Biden transition team. He previously served as Senior Manager of State and Regional Affairs for the Center of American Progress. Prior to entering politics, he worked as a civil rights attorney and a community organizer focused on language access, housing discrimination, and immigrant rights issues in minority and immigrant communities. Our next speaker is Thomas Saenz, who's the President and General Counsel of the Mexican American Legal Defense and Education Fund. He leads the fund's 5 offices in pursuing litigation, policy advocacy, and community education to promote the civil rights of Latinos living in the United States. He joined it in August 2009 after spending 4 years on the Los Angeles Mayor's executive team as counsel to the mayor. And he previously spent 12 years at the organization practicing civil rights law as a staff attorney, regional counsel, and vice president of litigation. He served as MALDEF's lead counsel in successfully challenging California's anti-immigration Proposition 187. And he graduated from Yale College and Yale Law School, and he clerked for 2 federal judges before joining MALDEF in 1993. Joanne Wallace is president and CEO of the National Legal Aid and Defender Association, which is the oldest and largest national membership organization devoting all of its resources to equal justice. She was previously the NLADA's senior vice president for programs and oversaw its civil legal aid and indigent defense program agendas. From 1994 to 2000, she served as director of the Public Defender Service for the District of Columbia, widely regarded as the nation's model for a public defender agency. And under her direction, the PDS challenged the efficacy of separating criminal and civil legal aid, created programs to reduce recidivism by addressing the societal challenges that often result in crime, and raised the quality of appellate representation and championed legislation that increased resources and encouraged more high-quality defense services. And she's also a founder of the American Council of Chief Defenders, which is a council of top defender executives in the United States. And she received her JD from the NYU School of Law. And finally, and I'm very pleased, sorry for the, anybody who's been on the Acela recently knows this is not surprising. I would like to introduce we have a designated hitter, a late addition to the panel, but we're very welcome to have Brittany Saunders, who works as deputy counsel to the mayor of New York City. And in this capacity, she provides advice on ethics and conflict of interest issues, as well as other legal issues that confront personnel in the office of the mayor. And she also supports the council's work to promote equal universal access to affordable broadband across the 5 boroughs, something I'm hoping we'll be able to talk about. Prior to joining the administration, she worked as a supervising attorney for immigrant rights and racial justice at the Center for Popular Democracy. And in that role, she provided both legal and policy support for the CPD's immigration and racial justice programs, spearheading the organization's work to combat discriminatory policing, promote strong public schools, and support family unity, and facilitate multiracial organizing and advocacy. Before joining the CPD, she was senior advocate at the Center for Social Inclusion, where she worked closely with community-based organizations, largely in the Black Belt South, to advocate for racially equitable transportation and broadband policies. And she's a graduate of Harvard College and Harvard Law School. So I think we can all agree an extremely impressive group, and so I want to get right to the discussion, particularly since we're a little tight on time. So let me start with Dennis Herrera, and I was just wondering if you could, as we've recounted, in your role with the city of San Francisco, you've seen a lot of progressive achievements, and I was wondering if you could talk a little bit about them, and also maybe if you had any lessons for how what's happened in San Francisco might be applicable to other municipalities. So we obviously have somebody from the de Blasio administration here, so it'd be good to know that how some of these achievements might play out elsewhere as well.
Well, thank you, Scott, and I'm anxiously awaiting your book. And I'm very happy to see that you and Riva have the exact right philosophy. And I like to think that the best defense is a good offense. And that's something that we try and do in San Francisco, fighting for progressive legal change almost every day. I was equally glad to hear both you and Peter talk in the introduction, talk a little bit about not focusing on the fact that there's only an opportunity to fight for change at the local and state level when there is federal inaction. I like to take a different tack, and that is looking at what you talked about, how states can be laboratories for change, and Peter talking about the historic nature that has always occurred at state and local government to provide opportunity. If you think about what occurred in the post-World War II era, all the way up until the beginning of the Reagan administration, there was a dramatic expansion of federal power, such that when Ronald Reagan came in and talked about a new federalism, people got really nervous. There was going to be all this power that devolved to states and localities, and people at the time rightfully said this is just an excuse to make an excuse for the federal government to get out of what it was that they had historically been doing. There were a great number of people that looked at that as an opportunity. And I have always been one that believes where there is tragedy, there is opportunity. But in reality, when you think about what has occurred, there have been a great many people. You look at what Senator Blumenthal did when he was Attorney General in Connecticut, what Elliot Spitzer tried to do when he was Attorney General of New York, what we have tried to do in San Francisco, what Eric Schneiderman has tried to do since he's been Attorney General. It has been to use the power of the law to make a difference in people's lives each and every day in a progressive way, and in a way that directly impacts people's lives. And I'm so glad that we have a good attendance of from students from great law schools, because I will tell you what I tell people when I go and talk to ACS chapters, that if you want to make a difference in people's lives, if you want to see how you can use the power of the law to fight for progressive change, there is nothing more rewarding than doing it at the state and local level. And that is not to diminish at all the contributions that you can make when you're involved in federal government. But it is an incredibly rewarding thing to see the power of the law be used to make a difference in your community. You just have to be willing to take advantage of the tools that you have at your disposal to fight for change. And I think that that is particularly appropriate to seize on the opportunities that you have at a time when there is a little bit of federal inaction. But you should not mistake that for saying that that's the only reason that you do it. Because you do have a tremendous opportunity to spark a debate, to spark a movement. I can remember when we started the marriage equality battle back in San Francisco in 2004, and Mary Bonato, I hope she's still in the room, a lion, and someone that we had used as mentors in the city attorney's office. We were a lone wolf out there following her lead, and there were a great many people that said, it's too much, too fast, too soon. Well, who would have thought that in 10 years, we would have had this tremendous expansion of marriage equality, which now I always forget. I used to know the numbers off the top of my head about what state, but every week there's a new state where we have marriage equality. That was directly attributable to the legal supporting the political, and the political then supporting the legal, and it's been a wonderful example of the symbiotic relationship that you see between law and politics. But I also think that it is equally important to learn from those lessons and then apply them in a different sphere. At a time when we're focused on income inequality and the economic challenges that a great many people still see in this country, to focus on what you can do at the local level to help spur a national debate. And I look at what we've done in San Francisco. Before the Affordable Care Act was passed, we happened to pass Healthy San Francisco, which strived to provide universal health care for the entirety of the population in San Francisco. I also noticed at the time that we had a gender rating issue in California, where women were charged 39% more for their purchase of individual health insurance policies as opposed to their male counterparts, even though in 18 states at the time it was illegal. We sued the state of California, and as a result, the legislature passed a law in response to our lawsuit, which then outlawed gender rating in California. You think about what we've done on wage theft. Our groundbreaking lawsuit against the nation's two largest payday lenders in the country at a time when they were taking advantage of our most economically vulnerable. We went after credit card arbitration mills, where they had fraudulent credit card arbitrations over the course of 4 years that against the National Arbitration Forum that impacted 35,000 Californians. These were all things that ultimately then were either taken up at the state or federal level. And I see that there is a role for litigation to play at the local level in a direct way to vindicate the rights of the aggrieved, but also to help spur a national debate and a policy response. Most recently, you may have read, some of you, about how there's an accrediting society that accredits all community colleges in the country, the ACCJC. They've threatened to close down City College of San Francisco, which serves 85,000 San Franciscans. We sued them for an unfair business practice and violations of federal law that is now spurring a debate statewide about the role that they play in accrediting colleges. So I give those as exemplars for the power that you have to make change at the state and local level. And I think that it's something that every student in this room and every practitioner should be mindful of. And I know that I have some unique tools available to me in San Francisco, both politically and in statute, but I think that if we look for opportunities, we can really spur change and make a difference in the country.
I think that's a very important point, too, about how it's not that federal and local politics are separate. There's a potentially symbiotic relationship where wins at the local level may trickle up and have effects at the federal level. So I think that's a great point. I wanted to turn things over to Tom Saenz and to bring up the issue of voting rights. I mean, I know when Chief Justice Warren was asked what was the most important decision of his tenure, he didn't say Brown or Miranda. He cited the great reapportionment decisions, Baker versus Carr and Reynolds versus Sims, and that line, simply on the theory that disenfranchisement was the injustice from which many of the other injustices flow. That by denying people the right to vote, it allows for all kinds of other arbitrary and unequal treatment. And so I know that you've been involved, and Maldives has been involved in a lot of voting rights litigation. And obviously, Shelby County has taken away one means of protecting the right to vote, but, that still leaves a lot of other potential legal mechanisms, and these are still struggles to be fought out at the state level. I mean, obviously, Shelby County doesn't require states to discriminate. It might make it easier for them. So I was wondering if you could talk a little bit about the work that your organization is doing and how you see the prospects for using both legal and other tools at the state and local level to sort of help to protect voting rights.
Well, Scott, I think that what you described about Chief Justice Warren indicates, of course, what we all understand and know, which is the right to vote is foundational. And so many other progressive aims and so many other progressive rights depend upon ensuring that there is a vigorously protected right to vote. And with Shelby County a year ago, really the Supreme Court took away a major effective tool to ensure voting rights, and not just in covered jurisdictions, but really across the country. Because even in non-covered jurisdictions, certainly there was attention paid to the decisions coming out of the Department of Justice and the District Court here in Washington, D.C. with respect to measures that adopted in pre-clearance states were then struck down or rejected through the pre-clearance process. So we're really all nationwide harmed by what happened in Shelby County. But you're right, there's still work to be done at the state and local level. Some examples from California is that California has had on its books for about a dozen years now a California Voting Rights Act. Now, it doesn't relate directly to what Shelby County addressed, but it does relate to the extreme difficulty, both in terms of resources and time, in using Section 2 of the Voting Rights Act, which remains on the books and applicable everywhere across the country, but using Section 2 to challenge electoral structures that dilute minorities' right to vote. Under the totality of circumstances test adopted by the Supreme Court, it's extremely difficult, fact-intensive, time-intensive, resource-intensive, to bring successful challenges. And what the California Voting Rights Act did is made it much more streamlined and efficient to challenge at-large electoral systems in California. With the result in the ensuing dozen years that literally jurisdictions that are at-large are falling like dominoes, and often it simply takes a letter indicating that there is the requisite racially polarized voting and a threat to sue, and jurisdiction after jurisdiction have generally concluded far better to move to a single-member district election system than to run the risk of losing a California Voting Rights Act case. I think it's had a tremendous impact. Add to that what's pending now in the state legislature, and knock on wood, hopefully gets through this term, an expansion of that California Voting Rights Act to apply to already districted systems, because so many of the most powerful jurisdictions in California, namely the boards of supervisors among others, are already districted systems, but at redistricting they have engaged in conduct that is pretty transparently violative of the Federal Voting Rights Act, but still very daunting to undertake Section 2 litigation. And another piece of legislation only recently introduced would create a state-level preclearance process for certain practices that have proven over time to often, not always, but often have been used to dilute minority votes and would subject those kinds of changes to preclearance by a state-level body in California. But I think it's important to note that all of this work really is directed to what's already been discussed, trying to leverage changes at the federal level. Because the simple fact is, as much as I, as a Californian, take great pride, as I'm sure my neighbor does, that California has become something of a progressive island, it doesn't do us any good as a nation to have progressive islands. We have to ensure that what's happening in state level is then used, leveraged to try to change federal policy. That means currently trying to ensure that the Congress moves forward. Thankfully, next week, the U.S. Senate is holding a hearing on the Voting Rights Amendments Act, but moves forward in responding to Shelby County strongly and vigorously and putting in place a new mechanism with at least as much strength to address the existing voting challenges nationwide. Because as much as I'd like to say we should declare victory in California and pick up shop and move MALDEF from our headquarters from Los Angeles to Phoenix, Arizona, first of all, as much as I have affection for Arizona, I don't want to live in Phoenix, Arizona. But more importantly, that's not really a way to accomplish kind of national civil rights aims that we're directed at. So it is always a balance, as I think both of you have suggested, between pursuing progressive opportunities where they exist, state and local level, but ensuring that you're being very intentional about trying to use that to leverage getting ultimately federal change and federal policies that would uniformly protect the kind of rights we're talking about. And I think it's important that we recognize that and acknowledge that there is a implicit danger if you're not intentional about that. Because too often, the reaction to some of these progressive laws, and I'll mention one, the state of California enacted last year what's called the Trust Act, which was a reaction to the over-enforcement of immigration laws on people who are not priorities in California and everywhere else, particularly through the Secure Communities program, and basically dictated that no sheriff or other local law enforcement officer in California could honor ICE detainer requests except under very limited circumstances. The reaction to that nationally was a national columnist writing, how come it's okay for California to do that, but not okay for Arizona to have SB 1070? So we have to be aware of that and be intentional about understanding and really coming up with a philosophy around the limits of federalism, that we want to be able to use local and state action, but as a tool to ultimately get to uniform federal action, that may mean having to accept some changes at state and local level that are troubling at the margins, but we have to be very clear that we're not going to accept other basic trepidations on rights. So I want to conclude by saying this. I'm a big fan of alliteration. Look at the name of this panel. Apparently so is ACS, Beyond the Broken Beltway. But I think we have to talk directly and explicitly about the other side of that. So Caroline, I want to suggest for next year that there should be a panel called Fixing Our Fetish for Federalism. And we have to be very clear about developing a progressive vision of what are the limits of federalism in the 21st century. Because regrettably, when we do this kind of experimentation, it is going to be used, at least rhetorically, by the other side, and we have to have a progressive response to that. Why SB 1070s are not acceptable when they tread on very basic rights and principles of this nation, while the kind of experimentation that's going on in California, among other places, is really appropriate under the laboratory category of moving the nation to a better place.
I volunteer to moderate that panel next year. So I'd like to turn things over to Joanna Shepard. As many of you have in front of you, she has a fantastic study called Justice at Risk, and it really looks at judicial decisions and campaign contributions. And many of us will have saw the very stark example of this several years ago. There's a case in which a West Virginia mining executive lost an appeal 3-2. People on his behalf spent more than $3 million on a judicial election. The judge who voted against him lost, and the new judge came in and whoops, discovered that in fact his legal position was correct, and he won 3-2. And that case was so egregious that it awakened Anthony Kennedy's sporadic conscience, and he argued that there was a due process violation. But obviously that's an extreme case, but the Supreme Court is not doing anything about the less egregious but still very important examples of this happening, that it's becoming fairly ubiquitous. And that might be an extreme example, but there are many more. So obviously it's an important issue, and so I'd just like if you could talk about your study and what you found and why this system of elections and campaign finance presents such a risk to our justice system.
Sure, absolutely. I'm going to attempt to use some slides. I think that some pretty pictures will hopefully be more impressive than me citing some numbers. So if you see me waving, I'm not waving at you, I'm waving at someone in the back to flip the slides. So this study is, the first study, I'll talk about another study in a few minutes, was really attempting to explore the relationship between the amount of money that's spent in state Supreme Court races and judicial decision making, and whether or not the money that's being spent is having any effect on judicial outcomes, judicial voting. Okay, so we were looking at specifically the amount of money spent across different retention methods. So this is just a quick map of the US that shows for the state Supreme Courts how different judges are elected. We have partisan elections, nonpartisan elections, a merit system where there's a combination of a nominating commission and the governor that chooses judges, and then straight gubernatorial or legislative appointments. So it's really quite varied, the amount of the different types of selection methods that we see that the different states use for the state Supreme Court justices. So when we're talking about experiments in democracy, this presents a great example. We're also, what we've seen happening in these state Supreme Court races is a huge increase in the amount of money that's being spent. This graph just shows you over the last 10 years, and you can see that it's regularly quite high. That Dark blue line at the bottom shows the independent expenditures that I'm going to talk a little bit more about later. The entire bar chart there shows the amount of money that's being spent. You know, back in the early 70s and 80s, there was very little money, if any, spent in state Supreme Court races. A lot of judges ran uncontested. It's a completely different ballgame now. Judges are regularly being contested. Instead of spending no money or a few $100,000 at the most, a lot of these races are gathering, you know, several $1 million in campaign contributions, and that's just the direct contributions that are made directly to the candidates. Even more is spent on independent expenditures, which are used for some of the TV ads that you may see depending on the state where you live. So we were really motivated by this to try to get some sort of sense of the measure of, is this money having any sort of effect? The importance of money in these elections is really giving wealthy groups, wealthy interest groups, the opportunity to influence not only what judges are being elected in the first place, but also how those judges might be voting once they're on the bench. So we have a lot of cute little anecdotal evidence about the influence of money on judges. So I always try and shake up the ACS convention a little bit by this first quote here, where a judge says, "I never felt so much like a hooker down by the bus station as I did in a judicial race. Everyone interested in contributing has very specific interests. They mean to be buying a vote." And so a lot of judges agree with this. You know, we even have quotes from the interest groups themselves, this one specifically is a labor union, where they said, "We figured out a long time ago it's much cheaper, or it's much easier to elect 7 judges than 132 legislatures." So that's really going on. There's different ways to affect the law, clearly, and legislative races tend to be a lot more expensive, and there's a lot more of them than judicial races. And then even surveys with judges that are done regularly, the judges themselves admit that they do think campaign contributions are having at least some influence on their decisions. There's also several empirical studies that examine this issue of whether or not the money is having an effect. Most of them find that there is some effect. I've authored a lot of those myself, along with some co-authors in this room, I believe. But a lot of those earlier studies were using data from the 90s. At the time, that was the best data that's available. So in conjunction with ACS, we've really, we tried to update that data to provide more meaningful evidence using current numbers and current figures. The money's changed dramatically. So our new study, the study that you're looking at right now, was trying to update the data to a 2010 to 2012 period. We specifically focused on the money from business interest groups in this project. So you can see here a pie chart showing where the money's coming from, and you can see that business groups are contributing even more than the political party or the candidate themselves to these races. Lawyers and lobbyists is the second largest piece of that pie. But we chose to focus on business groups, not because we don't think the other money would have an influence. We think it probably is very similar. But with business groups, it's a little bit more clear what their agenda may be. It's a little bit more clear when there is a case outcome, whether or not that would be pro-business. Lawyers and lobbyists have very diverse groups, very diverse interests, so it's a little bit more difficult to tell. Similarly, this is the money that goes directly to the candidates. If you also look at the money spent on TV ads, business groups by far exceed any of these other groups. So they're really a significant source of money in these state judicial elections. So just a brief kind of overview of what we did. We had a team of researchers coding over 2,300 cases from all 50 states over 2010 to 2012. We merged with this a lot of data on campaign contributions. And what we found was that there was a very statistically significant relationship between the money and the judges voting in business cases. Specifically, the more money that was spent, the more likely the judges were to issue pro-business decisions in a lot of these cases. We found that this relationship existed only in partisan and nonpartisan systems, not in the systems where the judges were elected by the governor or the legislature under a retention system. And we also found that it was a stronger relationship in the new period than it was in the prior period. 2010 to 2012, there's a lot more money. The money seems to be mattering more, so we did find a stronger relationship. This next slide shows just kind of a graphical representation of what we found. You know, I don't know, pictures always speak more than words, I think. And so basically we did find every dollar spent had a positive relationship on the likelihood of a justice to issue a pro-business vote. We actually found that it was a little bit stronger. The relationship was a little bit stronger for the Democratic judges than the Republican judges, which to some people at first glance may seem kind of surprising. It really wasn't that surprising to us. Republicans tend to be at a higher baseline in terms of their pro-business voting in the first place, so one would expect for money to have a smaller marginal impact when they're already at a much higher level. So, this study, we were just focusing on the direct campaign contributions. The one I'll talk about in a few minutes, we're looking at something very different. But we did find, in line with some of the earlier studies, but even using the updated data, that there is this very strong relationship between money and judicial voting, which should give us all pause and make us a little bit concerned about, whether money is distorting justice in a lot of these very important cases.
Yeah, and I'm glad you concluded that way, because that allows me to try a smooth transition of a moderator. That allows me to bring Joanne into the discussion. So obviously, Joanne has provided an enormous amount of empirical evidence about the impact that campaign spending can have on state courts. Obviously, at the NLADA, you can right on the front lines in terms of how problems at the state courts can affect issues of substantive justice. The real impact that this has on trials and therefore the day-to-day lives of a lot of people. So I was wondering if you could follow up and talk about some of what you've observed and some of the ways in which the problems of state courts are having a substantive impact on important justice issues.
So how does this translate into what happens in criminal cases, and what do we see with respect to how it impacts individuals, people who are charged with crimes? I want to focus first, I think, on the right to counsel and the relationship between fair and impartial courts and the right to counsel. If you care about the right to counsel, you have to care about fair and impartial courts. On the individual level, it affects the right to counsel, it affects it on the systemic level. So there have been great strides in improving indigent defense. We all know by now that we still, in jurisdiction after jurisdiction, still in crisis mode, but there are improvements happening. There are more public defender systems, there are more coordinated systems, there's more money in the system, although of course that varies. Not enough, but we're making improvements. But the fact of the matter is that in probably half and perhaps a majority of the systems across the country, representation is provided by private assigned counsel. And individuals who maybe they only take cases that are assigned by the court, or perhaps they have a split practice where they do some court appointments and they do some private retained work. So how this plays out is this, right? If you think about it, those individuals often make a good living. And in jurisdictions where they can elect and pay for campaigns of judges, lawyers do that, as we heard. What every person is entitled to in terms of the right to counsel is not just a lawyer at their side. That's meaningless. But in reality, and forget what Strickland says, the reality is that competent counsel, the right to counsel, is only meaningful if counsel is competent. If they're qualified, if they know how to handle the case, if they are appropriately trained, if they have the resources to do the job. It shouldn't be based on the amount of money that your lawyer has given to the judge who's going to hear the case, right? And unfortunately, when we go across the country and look at what's happening on the ground, you see those relationships. I am not a researcher, but if you're in court and you start tracking and looking at these relationships, you see patterns. Patterns emerge. And at the end of the day, people who are facing their loss of liberty, who are facing being convicted of a crime, losing their livelihood, their families, their homes are being detained, they have the right to qualified counsel. They shouldn't have to worry about, it shouldn't be an issue as to whether the counsel that they're getting is going to be beholden to the judge, or the judge rather is going to be beholden to the lawyer who appears in front of them. On the systemic level, we have, the courts play an incredibly important role in improving and reforming indigent defense. Most recent example, one of the recent examples of that is the case in Washington State, the Wilbur case, where the court in two jurisdictions held that the public defender systems were very deficient. It is critically important to have judges who are not beholden to money, who are independent, who are not afraid of political pressure in order to do the right thing. what has to happen is there need to be judges who are obviously competent in terms of legal analysis and the law, interpreting the law. They have to have a passion for justice, a compassion for people, and of course, be independent. If you think about this, you know, it has been a long time, if ever, that I've heard somebody is worried about being too hard on crime in terms of, you know, being elected to any position. And until that changes, it is critically important that we have an independent judiciary. When I talk to law students, of course, I'm always encouraging them to become legal aid lawyers and public defenders. But one of the things that I think is critically important for legal aid lawyers and public defenders to be thinking about now, and in fact, the whole bar, and one of the things I'm talking about is we need to go upstream. You know, if we care about the right to counsel, we need to go upstream and not only think about how do we attack judges' decisions, but how do we attack processes that are not promoting fair and impartial courts, and that needs to be a critical part of the a critical role that we play and a critical part of our thinking if we care about the right to counsel.
Yeah, I think that's fair. That Gideon versus Wainwright almost becomes an empty monument if it's not, you know, met with actual substantive effects on the ground. That's a critically important point. I'd like to turn things over to Nick, and I would first of all, I would like you to just tell us about the American Legislative Issue Campaign. That it's something that a lot of people might be familiar with. And since we're running short on time, rather than divide it up into a follow-up, I'll just ask you as well, if you could compare it a little bit to the American Legislative Exchange Council, that if I understand, Alice is trying to do some things differently than the way that ALEC does them. And so after you tell us about what the organization is doing, I was also wondering if you could kind of compare it to ALEC and kind of explain how what the difference is and sort of how you're approaching things differently.
Sure, thanks. I want to first take a step back, and this will answer your question, but to really underscore the importance of states and why they matter, because I don't think people fully grasp the power that states have. State and local governments employ 7 times as many civilians as the federal government does. They spend $2 trillion a year on domestic policy. Excluding military and mandatory spending, state and local governments spend almost 7 times the share of our gross domestic product. They're also active in legislating. You know, you talk about the Do-Nothing Congress. There was this last legislative session, 73 bills passed in this Congress. In 2014, 40,000 new state laws will be signed or will take effect. And then they also have broad powers. So by constitutional design, state and local governments hold the plenary and most commonly used government powers. They're in charge of things like public safety and health, education, environment, energy and water, transportation, housing, civil rights. And they also, as was mentioned earlier, have led the way on civil rights issues and have incubated what is now known as the federal social safety net, with Social Security, workers' compensation, unemployment insurance, and the earned income tax credit. So states are important. And I would say that the right has sort of gotten this a little bit better than we have on the left. And you know, probably since about the 70s, conservatives have been investing at the state level, not only on the electoral side, not only on candidates, but also on issue advocacy and moving legislation through the legislatures. And legislation that matters to them, legislation that advances their agenda. And they do it through a vehicle called ALEC, which is the American Legislative Exchange Council. ALEC is very powerful. Their budget, public budget, is about $6 million. But taking a look at, when you take apart the sort of in-kind contributions, state lobbying reports, that sort of thing, it's about $200 or $300 million that they use to advance legislation in the states. And they're very effective at it. If you look at Stand Your Ground, you know, within a year, they were able to get it in 13 states. Now it's up to 33 states. Our best example is marriage equality. How long did that take? And that's only because the courts intervened, and a number of other things. But it took much, much longer. And so, you know, and they have a very, very nice relationship, ALEC does, with corporate America. So it's corporate America, and it's connected to legislators through ALEC, who develops model bills for them, And then corporate America comes back on the back end and spends their money to lobby for those bills in states, and then give money to legislators for their campaigns. So it's a very nice relationship that they have. One example of that, as was mentioned earlier, is SB 1070 in Arizona. What actually happened with that law was that the prison industry, which is an industry, was in Arizona lobbying the state there to expand incarceration or facilities to incarcerate undocumented immigrants. And Arizona really wasn't sort of coming along. So where did they go? The prison industry went to ALEC, and they decided to form this bill where they basically incentivized or empowered state and local law enforcement to discriminate, to racially profile people. And so when you're forcing law enforcement to racially profile people who look like they're undocumented, it started increasing the number of people that they had to house, to question. And so they got their facilities, and they made money off of it. And that's how they work. So, and they're very good at sort of moving a proactive agenda as well. And we haven't really done that. And so what we're trying to do, I'm currently working under the radar. Just to give you a little bit of history on ALICE, it's been incubated for 2 years at the University of Wisconsin. It has, Caroline Frederickson, a lot of sort of progressive leaders around it, some donors, which is important. And it currently has about 2,000 laws, model bills that are in the library. It has about 200 experts from around the country that are sort of contributing to the idea mill. But it's a very good core of things. They recently got a little bit of money, and so my job now is to turn it into something that will actually start moving legislation. So you asked, if we want to be like ALEC. We don't. So I'm going to be changing the name of the organization and repositioning it, not to be like ALEC, but to learn from ALEC, because they're very good at what they do. And to try to move a more proactive strategy in the states. I don't see why, as progressives, we can't have the same proactive agenda. Why can't we move New York City's campaign finance law in multiple states? Why can't we move a civil rights agenda in multiple states? Why is it just them that do that, and we're always on the defensive? So that's the vision of the organization, and that's what we want to try to do. So currently, I'm sort of building out the infrastructure to be able to do that. Political operatives, state donors, and state legislators. So.
And another great point about the sort of separation between local and national politics is that local and state politics can be coordinated and produce results that are more national. And so I think that's a fantastic point as well. Tom mentioned earlier about the islands of liberalism, and another unfortunate aspect is that some of our islands of liberalism have not been terribly liberal in terms of their governors. So in New York City, finally the city hall has been taken over by progressive Democrats for the first time in a generation. So we're thrilled to have Brittany Saunders here. And it was just, basically wanted to ask you, obviously it's still, fairly early in the game, but, what successes have you had so far? What challenges have you had so far? Where do you see the agenda going from here? And, are there perhaps any lessons that other municipalities that may be moving in this direction can take?
Absolutely. I'd like to start actually by just kind of echoing some of the points we've heard about the really tremendous opportunity, particularly for the students here in this room, to think about your careers in local government, in state government. I, for one, am someone who had a really great experience in my local government course in law school, and then from there was able to get a bunch of different jobs with organizations that really focus on state and local policy reform. And then what attracted me to an opportunity to work for the de Blasio administration was an opportunity to then take some of those ideas and see from an actual position of executive office in local government, how could we actually make some of those ideas happen? How could we make them come to fruition? And so I'll focus on a couple of different initiatives that the administration is working on. I'll also say, just to kind of clarify a little bit, that I work with Maya Wiley, who is counsel to the mayor, and she, again, sends her regrets, but is really excited to hear about everything that we discussed today. But counsel's office is kind of unique. So we do some of the traditional ministerial advising work that you would do in any sort of kind of general counsel's office. But then we've also been tasked with helping to advance some proactive pieces of the mayor's agenda. And one of those is broadband equity. So this mayor has made the provision of universal affordable broadband access across the 5 boroughs, one of his key priorities. And we're thinking about doing that in a range of different ways. We're really looking at all the tools and all the assets that the city has at its disposal and figuring out how we can exploit them to really make that happen. So one thing that we're thinking about is, or actually working on doing, is an RFP for the thousands of payphones that are across the city. So, that is like 19th century, 20th century infrastructure, but we're really thinking about how can we change it and transform it given the enormous need for high-speed internet access. So we've got an RFP out right now, and the idea is to transform the 10,000 payphone structures across the city into installations that provide free, high-speed internet access and provide kind of a seamless web so that you're moving not from one network where you have to sign in and use a different password to another, but you're really moving throughout the city and having that access. And that's particularly important for populations like low-income individuals in New York City, people of color in New York City, which the national data shows us are more likely to have their primary access to the web via mobile devices. So that is one thing that we're doing. Another is that, related to that, along the same vein, is that in Harlem, we're launching the nation's largest continuous outdoor Wi-Fi network that is going to serve some 80,000 residents of Harlem. And again, the idea is that we're creating these access points that are publicly available and that give people access to the web in order to seek information, opportunities to connect to government itself, connections to art and culture, educational resources, and among others. Beyond that, there are a bunch of other areas in which this administration is really working hard and trying to not just be, again, like an island of progressivism, but really kind of set a tone for what other cities and what other states can do. So, for example, you are probably aware that one of Mayor de Blasio's major focal points is on universal pre-kindergarten, right? So we're working towards getting to the goal of 53,000 students enrolled in universal pre-K this fall, and getting to, I think, something like 75,000 in the 2015-2016 school year. And that is something that's going to completely transform the city, transform opportunity for children across the 5 boroughs, and something that we're really pleased in Council's office to have an opportunity to support. And then another initiative that we've been working on relates to paid sick leave. So earlier this spring, the city enacted its paid sick leave law. That's 1.2 million New Yorkers who are going to have paid sick leave for the first time. That's up to 40 hours of paid sick leave over the course of the year. And again, something that's tremendously important for working people across the city. And so it's initiatives like that that I think we are most excited about. There's a lot more that we are actively moving, and just really excited to be here to talk to folks about it.
Thank you very much. Detritus, we have about 20 minutes left. I wanted to turn to Joanna first, just because I promised her and promised you all to hear about her new work. So if you could let us know what the new study is about, that'd be fantastic.
Absolutely. So this study is also being supported by ACS. I'll just throw up a couple slides, if you don't mind. Just so I can show you kind of the motivation for this study. So our previous study looked at just direct expenditures to judicial campaigns. The new study is looking more at independent expenditures. So this is money that's spent by different groups, a lot of interest groups. They're largely spent for TV ads, and after the Citizens United case in 2010, which essentially said that there can be unlimited independent expenditures by corporations, unions, and other associations. It's really one of the biggest areas for concern right now in this area. So there was essentially, this shows the trends in TV ads. There were essentially no TV ads back in the 90s for these judicial races. Depending on the state where you live, you've seen some of them, and they're quite terrible and scandalous, and some of them are really kind of funny, I guess. The problem with the interest group spending in this area is that, there we go, is that the TV ads that are sponsored by the interest groups are much more likely to be attack ads. And there's, again, a lot of anecdotal evidence that these attack ads are concerning to judges because they're very concerned, is my vote in this case or my opinion in this case, is it going to become fodder for some future attack ad where I'm unfairly attacked in the TV in a way that the public thinks, I've done something terrible because clearly they don't understand all of the facts of the case, all of the procedural issues. Just to put up one more slide and show you kind of an example of this. This commercial is from a few years ago. This was an attack against an incumbent. And I'm sure you can read it from there, but it basically says, it gives you this terrible scenario of this person who was out on parole, was convicted of raping someone, and there was testimony and fingerprints and blood under the person's fingernails, but yet this incumbent judge voted to overturn the conviction. And obviously we don't know any of the facts, right? We have no idea what was really going on here. But this is very concerning to a lot of these justices. If you could click the animation one time, just one little click. There. So most of these ads, ironically, even though they are almost always about criminal cases and the way the judges voted in a particular criminal case, they are largely paid for by business groups. And nobody cares about tort reform. The public doesn't care about this at all. The public doesn't care about the other business issues. They do care about this sort of thing. And so, so that's kind of how we see the money traveling. So our new, you can take the slides off now. The new case that, the new study that ACS is currently sponsoring, I'm running it at Emory University, and we have a team of researchers that are currently coding a bunch of criminal appeals cases from the period 2008 to 2013, and we're trying to determine whether the amount of money and the importance of TV ads has had any effect on judges becoming tougher on crime, judges being more likely to rule against the defendants in these criminal appeals. We currently have a lot of the data coded. We have data for 11 states, which comes up to about 1,000 cases. By the end, we hope to have closer to 5,000 cases coded. But the preliminary results from this data, once we merge it with some of the other, the data on the campaign contributions and that sort of thing, is that the money is mattering, that the judges are becoming tougher on crime. Specifically, and we use Citizens United for this a little bit. So Citizens United removed the ban on independent expenditures. Since then, we've seen a lot more independent expenditures, an explosion of TV ads. And what we find is that when that ban is removed, judges become about 10% less likely, 10% tougher on crime, you might say, 10% less likely to vote to overturn the criminal's conviction. So they're basically, more likely after Citizens United to vote to keep the defendant in the current position. So obviously this is concerning. This is different than our previous study where we were looking at civil cases and business outcomes, which are clearly important. Now we're talking about criminal cases, and we're talking about how long someone spends in prison. Do they go to prison at all? We think this is a growing problem after Citizens United with the rise of TV ads. And so again, just one more area of concern that I think is relevant to a lot of the work Joanne's doing as well.
Absolutely. And I wanted to turn things over to Tom, just because there's one issue we haven't talked a lot about, which is education. I mentioned earlier that we're running the risk of sort of hollowing out Gideon versus Wainwright, sort of creating an empty right to counsel, and the same thing is happening in many jurisdictions with Brown. That on the ground at least, local school districts are becoming both separate and unequal. Indeed, as Justice Douglas observed 40 years ago, we're not just retreating beyond Brown, we're retreating beyond Plessy. With courts sanctioning school systems that are separate but unequal. So I know that MALDEF is also doing a lot of work on civil rights and education. So I was wondering if you could tell us what you've been trying to accomplish at the local level.
Sure, Scott, and I think it relates almost directly to what Joanne was talking about. It's not as easy to document, but I can certainly give anecdotal evidence of where really relying on state court judges has created major implementation and long-term success issues in the area of education equity. Of course, here, we're in state court not by choice, but because 41 years ago in San Antonio Independent School District versus Rodriguez, the U.S. Supreme Court basically abdicated any responsibility, even after Brown, to ensure education equity, and was going to focus, and it doesn't even do this anymore, on specifically issues of de jure segregation. And so all claims of education equity were then left on the doorstep of state courts enforcing state constitutional guarantees of sufficient, adequate, equivalent education, whatever the particular wording of the state constitution may be. And MALDEF, along with another number of other groups, have pursued these cases in states across the country. But what we have seen time and again is that when you're in front of elected state court judges, they are reluctant to tell elected state legislators that they must do certain things. And so the pattern that we've recently seen in Colorado and then in Texas is you'll get a very good ruling from a trial court judge who considers all the facts and evidence before them that in fact there is an adequate investment in ensuring equitable educational opportunity for all. And in response to that decision that inevitably receives widespread media attention statewide, the state legislature and governor will do something. Not nearly enough, but they'll throw a little more money at the education system. And as a result, what we've then seen is some reversal or potential reversal in what the state court judges do. So in Colorado, basically there was a very powerful trial court decision. And while it was going up on appeal to the Colorado Supreme Court, the Colorado legislature did something, not nearly enough. But in response to that, the Colorado Supreme Court overturned the decision, well-reasoned decision of the trial court, and concluded that there was no longer a showing of a violation. What we've seen in Texas, which we seem to have to litigate every decade, sometimes even sooner, the adequacy and the equity of their school financing scheme, go back to Rodriguez, also came out of the Texas system, perhaps the worst of all of them across the country. But what we've recently seen in the recent case is a powerful ruling from a trial court judge. In response, the Texas state legislature actually catalyzed to do something to invest in education. I know shocking that may be, but not shocking that it was not nearly enough. And as a result, that trial court judge decided he had to retry the case and went through a mini retrial earlier this year. Now we're still hopeful and confident that the showing is still sufficient that there is a violation in the Texas school financing system, but obviously concerned about what the outcome may be. So it really epitomizes in anecdotal form the difficulties of being confined to state court, state constitutional remedies, and why ultimately we really have to ensure that we are getting the kind of vigorous federal monitoring at minimum, preferably policy setting and real efforts in implementation around a lot of these equity issues. Again, I think we have to really discover as a progressive community what is the right balance where we can use state and local initiative very powerfully, as we've heard examples today at both local and state level, to really catalyze federal change in a progressive way. But at the same time, we don't want to leave so much decision-making and discretion at the local level that we lose any uniformity of commitment to the kinds of values of equity and equality of opportunity that are bedrock.
And I assume by federal enforcement, you don't mean the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. That's not quite, a little more than the Chief Justice's tautologies, I hope. I wanted to turn to Dennis. You mentioned it briefly, but I wanted you to say a little more about this. That I think Barbara Ehrenreich, among many others, has observed that it's very expensive to be poor. That ironically, people with the least money often are subjected to having to, pay weekly rents at hotels, borrow money at extortionate interest rates, subject to more kinds of fraud. And I know that's something that your office is very much concerned with in terms of payday loans and fraudulent credit card deals and so on. Obviously, thanks to the Supreme Court in Concepcion, I guess some of California's jurisdiction has been tied there. But I was wondering if you could tell us some of the work you're doing there and why you think it's so important. Because I think these are issues that sometimes fly under the radar, but I think are immensely important.
Yeah, I alluded a little bit earlier to what we have done and how important it is in this era of when everybody's focused on income inequality. And understand most of the cases that we bring to protect consumers and those that are least fortunate in our society are brought in state court under our unfair competition laws, as well as local statutes. So we've had the opportunity to get involved in a lot of areas which I think really bring direct relief to individuals. Credit card arbitration fraud, wage theft, which has been a real problem in San Francisco. Payday lenders, going after the nation's two largest payday lenders for defrauding thousands of Californians in terms of loan practices over the course of a 5-year period, to the degree that we got over $16 million back for California consumers. These are the kind of issues that we have the ability to get involved in. And to Joanna's point, and I think a little bit to Tom's point, the importance of where is it that I'm litigating this stuff. It's in state court. And I think that that is incredibly important to focus on. I haven't had the range of experiences as Tom has. I'm always in California State Court, but I think that California did get a little bit ahead of the curve back about 5 years ago when our Chief Justice at the time, Chief Justice George, established a commission on the independence of the judiciary to focus on these exact issues. So for us, at least in California, and the ability to seek redress on behalf of the aggrieved, the fact of the matter is, it really doesn't enter into my mind that much that I have to worry about a judge that has really succumbed to political pressure, because I think we have been at the forefront. But I recognize from what we read in the paper in West Virginia and Iowa that this is a real problem across the country. And I think that we have been proactive in California to make sure that we have a judiciary that has not yet succumb to that. And I think in terms of the effort that you've seen, you haven't seen the explosion of money from special interest groups yet in California, because I think that they recognize that we're sort of watching for it. And I can tell you it would make my job infinitely more difficult in terms of the work that we have been involved in if I didn't have a well-balanced and independent judiciary to faithfully adhere to its role. And I view us as the cases that we get involved in. I have a really simple test for the cases that I get involved in. Number one, is there something unique that I can bring as a public prosecutor and having the imprimatur of the city and county of San Francisco representing the people? Do we bring something to the table? And number two, is it something that the private bar, is it a vacuum that the private bar is already filling? And if it doesn't satisfy those two criteria, I don't get involved. So it has to, I'm very sensitive to bringing the full weight and power of the city and county of San Francisco behind a case, and recognizing that there's something unique that we bring to the table as a public prosecutor. And it's these areas in this era of income inequality where I think that we're really going to focus.
Incidentally, what kind of judicial electoral system does California have? Is it an appointment and retention, or is it a straight election, or I forget?
Well, you can do either. At the Superior Court level, gotcha. You can run, or you get appointed, and then you have you have an election. But then it's appointment retention when you get up to the Court of Appeal and the Supreme Court.
Yeah, and if I understand your data correctly, the sort of appointment and retention systems are a little less subject to corruption than the straight election systems. Is that
well,
right?
Right. There's not really money spent.
Right.
I mean, it's the gubernatorial appointment, so they aren't running in front of the voters. There's no TV ads and that sort of thing.
And
so
it's harder to mobilize around a recall retention election.
Yeah, typically.
That's great. Yeah. I also wanted to turn back to you, Joanne, because these issues that you talked about, the importance of an independent judiciary. You already talked a lot about the right to counsel, which is of course critically important. What are some of the other issues you've observed from the front lines about weaknesses in state judicial systems that, apart from the right to counsel, what are some of the other barriers to equal justice that you've seen in your involvement in these cases?
Right. So the critical factor for justice, I mean, in order to have fair and impartial courts, you have to have independent and qualified judges, right? And so that's really the linchpin, and anything that threatens that is going to threaten justice at all levels. And I'm here with my sort of criminal defender hat on today, but of course that's true whether it's criminal court or civil court, where you're dealing with basic human needs. I think that what happened in Oklahoma a few months ago, the horrifically botched execution, is an example of what can happen when and how damaging it is to our justice system, to our democracy, when we do not have qualified, independent judges. And I mean that not only in fact, but in perception, right? And for those of you who may not have followed the case of Clayton Lockett, before he was executed, the court had stayed the execution at a certain point, and then there was a resolution in the legislature to impeach the judges who had voted to stay the execution. And is there data that they're connected? No, but after that, surprise, surprise, the stay was lifted. And then if that wasn't bad enough, not only was he then executed, but he was executed in a manner that was really torture. They couldn't find his veins, the medicine, the medication that he was given that was supposed to knock him out so that he would not be conscious during this procedure apparently didn't work. And it was, I mean, frankly, I cringe even talking about it. So, you know, that is not what American justice should be about. And key to making sure that, you know, that major principle of democracy is upheld is the judiciary. So we've had, you know, really tremendous successes, as I was talking about before, and we're making strides on the state and local level in terms of the right to counsel in the legislature, in the courts. A lot is happening, a lot of positive and good, but at the end of the day, it's about justice, it's about individuals, it's about life and death, and judges make a difference. So we need to get involved there.
And I'm also, I think another good death penalty example would be the way so many state courts have evaded the Supreme Court's holding that it's unconstitutional to execute the mentally handicapped. Now, part of that, as Tom might say, is that I blame the Supreme Court for not having a very, you know, for having a fairly vague standard, but it is clear that, you know, state courts seem to be just, you know, effectively evading the ruling, clearly upholding death sentences to people who should not be executed under the Supreme Court's understanding of the Eighth Amendment. So there are plenty of, you know, gruesome examples of this. So I think that's a really important point.
Can I make a quick point, which is sort of related to this? I think even where you don't see the influence of money or not as much of it in California, I think there's a value in looking at, and I've just been doing this as an observer in seeing my sample ballot, the evolution of occupational ballot labels for candidates for Superior Court. I don't know if it's happening elsewhere in California, but in Los Angeles County, they used to be labeled Assistant District Attorney or District Attorney's Office. Now they've evolved to, they label themselves Gang Prosecutor or Child Molestation Prosecutor. It's this escalation in trying to sell yourself in an election where there's not a lot of public awareness of the issues, in part because there's not investment by anybody in these elections, but they are pandering to what they view as the interests of the voting public, and that is really degraded, devolved the kinds of occupational labels you see on the ballot in Superior Court elections in California.
And to put on my political scientist hat, I think there's sort of a perception that more elections always means more democracy, but that's not necessarily true. That a lot of these elections, you know, I mean, I study this stuff for a living, and I couldn't tell you much about the candidates for New York State Comptroller. That when you're talking about low-level, largely nonpartisan elections, it's simply not realistic to expect an informed electorate. Not because the typical voter is stupid, but because there's, you know, these are things that experts have trouble keeping informed of. And I think that's one fallacy that's led to the findings that we've seen from Joanna. That, you know, the right to vote is critically important and enfranchisement is important. That doesn't necessarily mean that having elections for every office. There are a lot of offices that are appropriately appointed by electorally accountable officials rather than directly elected. And I think that we've seen, you know, the wages of that throughout this. Nick, I wanted to turn back to you, and, you know, because we finished up my last question talking about the potential for you know, coordination, that local politics can be made more national. I was wondering if you thought, are there any issues in particular that you think that progressives can, you know, coordinate along, you know, whether taking the initiative from the de Blasio administration or from the city of San Francisco? What are some issues where you think that a lot of progress can be made at the state level through, you know, coordination in the way that something like a progressive alternative to Stand Your Ground, like what could be an example?
Yeah, I mean, I think there's a ton of actually examples, and we're kind of sorting through that right now. I think after Citizens United and a lot of those sorts of cases, there's a real appetite at the state level for campaign finance reform, you know, tying or holding corporations more accountable for, you know, their giving, that sort of thing. I think minimum wage is still a very good issue, and you know, you see examples at the city level, San Francisco, Seattle, really pushing the envelope. I think that is also ripe. You know, if you look now, someone making minimum wage is at like $14,000 a year, which is horrible in this country. And so I think that there's a real opportunity there. And you know, civil rights, there's just a slew of different things, and currently we're working to identify, you know, talking with legislators, talking with experts, talking with local elected officials and others on what is the right sort of suite of issues that we will likely be focused on to advance different things. I don't want to take up too much time, taking through all of them, but there is quite a few that I think are ripe and really where we can actually move a proactive agenda at the state.
And I guess I'll turn that over to kind of ask the same thing of Brittany, as somebody who's actually part of a new progressive administration. If there's anything in particular that you're looking to accomplish in the next year, do you see any roadblocks?
Yeah. So you asked earlier, are there lessons that you think we can draw from the things that we're doing in New York that are applicable elsewhere? And while I think it's a little bit early for, lessons, I will say that the thing that is kind of a driving principle for the de Blasio administration, and something that I encounter in every piece of work, no matter how kind of, specific and detailed, is the importance of equity. And so I think, it may look obvious now, right, that Mayor de Blasio has been elected, but it wasn't obvious, a year before the election that was going to be the unifying theme that was really going to drive people out, and that would be driving the subsequent administration. So I think what I would say is that I hope that, years from now, I'll be able to look back on the work of this administration and say, we were able to take equity into each and every piece of work that we did, each and every aspect of our agenda, and make a really strong statement about how local government can really advance racial equity, gender equality, all sorts of other aspects of equity.
Does anybody else have any thoughts to sum up?
Well, I also worked in what was viewed as a progressive mayoral administration. Came in with great promise. Mayor Villaraigosa was elected in LA. He was the first Latino mayor in 132 years, and really had been elected over another Democratic incumbent, but viewed as a more progressive potential mayor. And I think we came in with lots of promise, and we came in with lots of ideas, including making equity really a co-equal goal with a lot of other goals related more directly to specific services. And then the 2008 recession hit. And as much of a progressive island as California is, we're sort of hamstrung with these measures that prevent us from raising revenue at local or state level without, having papal dispensation and 55, 65, 75% of the vote. So it really made it impossible to do anything in response to that. And that's when the ability to take progressive initiatives and move them forward came to a halt. And I used to tell people I knew it was time to leave when I viewed it as a good day if we were able to hold off layoffs for one more day. That was progress for that day at the mayor's office. So I think we really also have to focus on, across the country, but certainly even in progressive islands like California, about making sure the government has the resources that it needs, the revenues that it needs to really pursue the progressive aims that we're talking about pursuing, because it becomes utterly impossible if you don't have the resources available to you to do this.
Well, if we get your federalism panel together for next year, we'll have to talk about the fact that states are basically required not to engage in counter-cyclical fiscal policy, which is a major problem in this, that recessions actually hit hardest at the level where we most need to give support. So I think that's something that's an issue that progressives really need. Any other firm thoughts? Well, although we're ending a touch after our scheduled time, we were given extra time. So we're actually, very rarely for a conference, we're going to get people out of here on time. So thank you so much. What a terrific panel. I learned an enormous amount. I really appreciate everybody for coming, and I really appreciate so many intelligent contributions. This is fantastic.